in a line or a series of cases decided by our Supreme Court, 5% per month is unconscionable rate of interest. So it is synonymous with usurious rate of interest. And this is being disallowed. Yan. Ayan po ha. Kaya yung mga nagpapautang ng 5%, mag-isip-isip kayo. Okay? Okay, tuloy tayo. So, nandun tayo, yung junior mortgage, yung pangalawa. Siyempre, priority yung nauna. So, wala namang senior mortgage. The first mortgage. Parang birth certificate yan. Mayroon bang pangalan na may nakalagay na senior? Wala. Pero yung junior, mayroon. Ganun din ang mortgage. So, open mortgage or closed mortgage. Well, ito, madalas ito ibigay sa exam. What are the different kinds of mortgage? Pero, yung ating mga examiner sa board, they don't choose the word open or closed mortgage. Sometimes, if I recall, there are a lot of board exams whereby the questions deals on anaconda close. Anaconda. Anaconda close. So that refers to closed mortgage. Why? Di ba, ang anaconda ay ahas. Pag pinuluputan ka ng ahas, hindi ka na makawala. Kaya lahat na nakalagay sa basket at nilagay doon at pinuluputan ng anaconda, ay hindi na pwedeng bawiin. Until such time, the loan is fully paid. Regardless of how many collaterals you put that in basket, in the contract, that is continuing, you cannot pull out the security. Yan po ang closed mortgage. Yung open, so, in our banking system now, most of the bank, if not all, does not allow open mortgage. Gusto nila closed mortgage. Kung ano yung sinanla mo, yun lang. But there are still banks. I know a certain bank, government bank, that allows open mortgage. In fact, I have a pending case against that bank. I will not divulge what kind of bank. But we have a pending case. Ano naman yung legal mortgage? So, legal mortgage is a mortgage that is considered legal mortgage by virtue of a law. No? Yan po. So, nilalagay yung iyong property as security because you have, normally, it is an obligation due or owing to the government. Okay. The most controversial kind of mortgage is equitable mortgage. Actually, this is not mortgage. This is being abused by most lenders. Instead of having a contract of mortgage, they just prepare a contract of sale or deed of absolute sale blank. So just in case you fail to pay the obligation, the loan, they will fill up the blank contract of sale or deed of absolute sale, and the property will be transferred to the mortgagee or to the lender. Ito madalas ang lumalabas sa korte. Equitable mortgage. Yan ang madalas gamitin ng mga nagpapautang, ng mga usurious lender. 10%, 20%. Akin na yung titulo mo. Ito pera. Tapos papipilipin ka, papipirmahin ka ng deed of sale, blanco. Ayan. Kaya kung kayo, broker, appraiser, tingnan nyo yung mga ganyan dokumento. Ano ba? May utang ba kayo? Opo. Ano ang papel? Deed of sale. Ayan na, magduda na kayo. Equitable mortgage yan. Okay? So, ano ang nature ng mortgage? Indivisible. Bakit indivisible? Kasi hindi mo pwedeng paghiwalay-hiwalayin. Ito, may tanong dito. Is it legal to forfeit earnest money when sales transaction did not push through? Well, as I said, you have to refer to the contract of sale or rather to the contract, no? Or contract to sell, no? Yun ang pinaka-primary document nyo. Doon nakalagay yung ground for forfeiture. So may mga batas dyan. Unang-una, yung batas natin sa Maseda Law. Ha? Kasi yun ang may earnest money. Kasi yung client ko, 1 year at 5 months na lang kulang sa down payment. Ngayon, ang project 3 years from now, 2023 pa matatapos. Nag-request sila na mag-stop muna sila tapos resume January 24, 2024. Sa down payment without penalties, kasi 3 years pa din naman, tapos ang kulang nila 1 year and 5 months na lang, nag-request kami ng letter for approval. Dapat ba mag-approve sila? Gusto i-post ni client, no penalty kasi delay naman sila ng promise of turnover. May laban ba kami? Refer to PD 957. Ha? So you can exercise the right to suspend payments because of failure of the developer or the project owner to fulfill their obligation. And what is that obligation? To complete the project within the time frame agreed upon. So you can suspend payment. Huh? By stating among others that you are suspending temporarily your monthly amortization or monthly installment payment because the project is not yet started or the project is below the percentage of completion. Kalimitan ganyan ang nangyayari. Pero you cannot say na, oy, Mr. Developer, Mr. Owner, hindi mo na ako magbabayad kasi matagal pa naman eh. You cannot do that. There must be a legal and factual ground, no? Ano bang batayan? O yun, PD 957, legal ground. Ano naman yung factual? Hindi tapos eh. Kung mapapansin nyo, yung mga broker, appraiser, balikan nyo yung tinatawag na provision, yung tinatawag na shine clause, no? Although the developer has not completed within the time frame or period as approved by the regulatory body like DSUD, no? Ngayon, DSUD na. Di ba mayroong project, mayroong period within which to complete the project. Ayun. Pero pwede silang humingi ng extension. Normally, 6 months. No? Depende sa factual circumstance. But the most that the regulatory body can give is 6 months. Lalo na pag mga pondo. Nagsanla po ng lupa ang isang lending institution sa isang lending institution. Napabayad at di nakabayad dahil nag-migrate sa ibang lugar. Pwede bang bawiin ng property through buyback? May karapatan bang ibenta? Well, mamaya pag-uusapan natin, ha? Kaya doon tayo sa foreclosure. Foreclosure, ano remedy? Ha? Ayon, redemption. Yan ang remedy, redemption. Okay. So, balik tayo ron sa nature of mortgage. So, mortgage is indivisible. Indivisible in the sense that the real property mortgage is directly responsible and liable for the fulfillment of the obligation or full payment of the loan contract, and upon failure of the mortgagor debtor, the property may be alienated for the payment of the loan contracted by the mortgagor. So, hindi pwedeng, sabi ko nga sa inyo, hindi pwedeng sole ang collateral o yung security hanggang hindi na babayaran. Kasi indivisible eh. kung mayroon ka mang ibang property, nakalagay doon sa isang utang, 2 or 3 or even more, so hindi pwedeng kunin. Kahit na the title is covered with different TCTs, CCTs, yet the mortgage is indivisible. It will be taken as a whole. Kabuuan, hindi pwedeng tingi-tingi. Okay. And it is a lien attached to the property. So whoever the possessor may be the fulfillment of the obligation. Thus, the sale or transfer of the mortgage property without the knowledge or consent of the creditor does not affect the release of mortgage. Kaya it becomes now a practice in order to bind third person or the public, the creditor should register the mortgage. Otherwise, there will be a problem that will crop up later on. Kasi yung bali bibili, akala ko walang utang to because the title is clean. When I conducted due diligence, the title, the certified true copy, has no encumbrance with respect to mortgage. So, pwedeng sabihin niya. But, that is the common situation. But legally speaking, registration is what? Just an evidence. Registration of mortgage is just an evidence, a good or a best evidence of existing mortgage. But it does not mean that even if it is not registered or annotated in the title, there is no mortgage because registration is synonymous with consent or knowledge of the fact of mortgage. Kahit hindi nakarehistro yung mortgage, pero yung bumili, alam na alam ang nangyari na ito ay may utang. Yung may-ari ay may utang. In fact, siya ay testigo doon sa utang. Ayan. Pwede yung ganon. So, in a sale of subdivision lot or condominium unit, the instrument of mortgage must contain a stipulation that the mortgage shall be released as soon as the full purchase price is paid to the buyer. Marami nangyayaring ganyan, no? Yun ang naging isang problema ng isang buyer ng isang condo with the project is collateralized, meaning while they are building the condo project, the project developer or the owner applied for a loan. So nakasala ang buong condominium unit o condominium project. So ikaw naman bumili ka, reselling, nabayaran mo. Hindi natuloy, na-foreclose ng bangko o ng financing institution. Ano remedy mo? Kaya nahihirapan ng mga buyer ng bumili ng tingin ng unit. Kasi ang bangko, hindi rin papayag na bayaran mo lang. Bayaran mo lang yung unit mo. They are not allowing that. In fact, I have experienced that. I have a client in somewhere in Ermita. Yan lang yung problema. May mga nakabili ng condo, ilang units. But the entire project was mortgage to back. Pero yung iba naman, pumapayag naman yung financing institution. I have a condo. Yun nangyari. Nasa akin ng susi, 20 units ata, Hirin Malate. Foreclose na yung project, the entire building, the entire condominium. Pero yung aking kliyente, fully paid. Fully paid. So, he asked for the release of the CCT, and it was released. But it was released when I was not the lawyer. So the problem is, the original, the owner's duplicate, nowhere to be found. So yun ang problema namin. Yung kliyente ko abroad, walang representative, foreigner, up to now, hindi namin ma-occupy. Kasi we have to pay almost about 5 million just to pay the annual dues. The dues has already piled up. Yung condominium dues, milyones na. And the building administrator does not allow me or my representative to enter the premises until after we pay at least 1 unit. Kasi 20 units eh. O ngayon ang tanong, sino ngayon nagpapaupa doon? I don't know. Kasi wala kaming access. So, it is a lien attached to the property. Coverage. So the mortgage extends to and covers the natural accession of the property. The improvements, growing fruits, including the rents, income, therefrom that have not been received when the obligations become due. So anong ibig sabihin yun, the natural accession to the property? Remember the general concept of principal and accessory. So the principal follows the principal. Similarly, the fruits of that property is also part of the principal. So it becomes part of the principal. So you cannot say, oh, total naman, ang isinanla ko lang naman sa iyo, itong lupa, ay yung mga tumubo diyang pusa. Kunyari, may mga puno ng kahoy, puno ng mangga, at inaani. O sino ang makikinabang niyan? Of course, the owner. But pagkakuha na kayo, default na kayo, hindi kayo nakapagbayad. So the fruits of that principal property mortgage also includes the fruits, including the rents. Ngayon, kung ngayon ay apartment. So, ang tanong, sino ang pwedeng kumolekta ng rental? Kung na-default kayo, tapos may rental, sino may-ari ng rental na hindi nakokolekta? So yun ang issue. Mamaya titingnan natin. So the amount of indemnity due to the owner, the insurer of the property mortgage. O di ba yung mga loan natin, yung mortgage, ina-apply yan, fire insurance. O kaya pagka nasunog, sino makikinabang? Yung may-ari, nagsangla o yung pinagsanglaan? Of course, yung pinagsanglaan. Kasi nga, yun ang kapalit, indemnity insurance. Yun ang ipapalit. Kasi wala na yung collateral, yung building, nasunog, anong pangbayad niya? Wala. Already indemnity insurance. So, ang mangungulekta, hindi yung insured, kundi yung creditor, yung nagpautang. Or in virtue of expropriation, public use pursuant to the declaration, application and limitation established by law. So this is whether the state remains in the possession of the mortgagor or it passes into the hands of this person. So, it covers everything. Kung naka-mortgage, yan, hindi lang yung principal, kasama ang fruits or any accessories, including the insurance. Alienability, ayan. Ito, tanda-tanda nyo yan. So even if there is an existing mortgage, the property may be alienated or assigned to the person in whole or in part. The creditor, however, may claim from the third person in possession of the mortgage property, the payment, the part of the credit secured by the property. Any stipulation forbidding the property from alienating the immovable mortgage is void. This clause is known as pactum di non aliendum. So I have an existing case now in Sorsogon regarding this. When I examine the contract of mortgage, it is a private financial institution. So it was stated in the contract that the mortgagor, the property owner, is prohibited from selling, mortgaging. Ha? Ayan. So, I took notice on that. So, that is my ground in filing a petition for the annulment of the foreclosure of mortgage. On the ground, the mortgage itself, the mortgage contract is void from the very start because there is a clause pactum di non aliende, a clause or a provision in the contract of mortgage prohibiting the alienation or transfer in whatever form to third person by the debtor or by the owner of the property. Yun. Ha? So that's void. Stipulation of mortgage that upon failure of the mortgagor to fulfill his obligation, the creditor mortgagee should appropriate the property mortgage as his own. Is likewise void because this is contrary to public policy. So yung wordings na yan, ang tawag doon ay pactum commissorium. So, mayroong contract of mortgage na nakalagay sa kontrata, kapag hindi ka nakapagbayad, automatic, mapupunta sa kanya ang property. And this kind of stipulation was already disallowed. But during the old times, when we were still under the Spanish regime, Spain, no? So, kung makikita natin yung mga titulo, meron doon yung mga transfer of title by way of mortgage. So, failure to pay the mortgage, automatically the property subject of mortgage becomes what? The owner of the creditor. The property of the creditor. But under the Civil Code of the Philippines, the new Civil Code of the Philippines, by the way, the Civil Code of the Philippines becomes effective bago pa tayo magkaroon ng 1935 Constitution, 1932. Hindi pa rin. Ang aking Civil Code, nandiyan pa rin. Pinaka-luma ng batas. Kasi ang ating criminal law ay na-amend na. Pero yung Civil Code natin, yung ating mga congressman kasi, senador, wala namang ganong pakialam dyan. Hindi naman kasi sila makikinabang yan. No? Okay. So, ito yung dalawa ang void. Isang pactum di non aliende, pinagbabawalan ang may-ari ng real properties na ibenta. Kasi merong pending mortgage. Bawal po yung, kahit nakapending yan, mayroong utang, hindi po dapat siya pagbawalan na ibenta kanino man. Kaya nga po, kung kayo ay nakapangutang, mayroon kayong pangangailangan, pwede kayong magbenta. Ibenta nyo yung rights nyo. O ibenta nyo mismo ang karapatan nyo. O ibenta nyo mismo yung pinagsanlaan nyo na property. Kaya kung nakalagay dyan sa kontrata nyo, bawal po yun. As if there was no contract of mortgage. Okay, so, ito, ang kadalasan din nangyayari, yung pactum commissorium. Pag hindi ka nakapagbayad, mayroon ng transfer. So, ginagawa nila, mayroon ng blank deed of sale. Yun nga, balik tayo rin sa equitable mortgage. Bawal din yun, equitable mortgage. No, equitable mortgage, hindi bawal. Kasi you can only determine equitable mortgage through judicial action. So, kung wala kang final na kaso, you cannot tell that the contract of sale is a contract of mortgage. Yung pang ibig sabihin no, na equitable mortgage. So, dito naman sa alienability, bawal po yan kung mayroong provision o mayroong stipulation na nakalagay na pag hindi ka nakapagbayad, sa kanya na yung property mo. Okay? So, yun po. So, tingnan natin, silipin natin kung mga tanong. Okay. There is a case na di sinusunod ang kasulatan na pupunta sa kaso, natural. Breach of contract. Pupunta kayo sa korte. Nagsanla po ng lupa sa isang lending institution. Nababayan, di nakapagbayad dahil nag-migrate sa ibang lugar. Pwede bang bawiin? O, sabi ko sa inyo na, ano yan? Mayroon. Tingnan natin mamaya, ha? Suppose there is no contract of sale. There is an oral agreement and deposit. Can you forfeit the deposit after lapse of 3 months or more? Alam niyo po, ito para sa kalaman ng lahat, you should always remember that any contract agreement pertaining to real properties must always be in writing. Otherwise, that contract is unenforceable. Unenforceable. Hindi void. Unenforceable because of failure to follow the so-called formalities. In fact, aside from unenforceable, you could say na void. Because unless that is the exception to the rule, there is only one kind or instance whereby contract of sale made orally is valid. An actionable, that contract, though oral, is an actionable. Bakit actionable? Bakit? Because according to the Supreme Court, said, when an agreement between two parties, an offer to buy and an offer to sell made simultaneously by the prospective buyer and the prospective seller, simultaneously, there is consent. There is consent. Although, it runs counter to the general principle, general law, that contract pertaining to real properties must be in writing. Otherwise, it's void. Bihira po yun nangyayari. Kumbaga, 1 in a million years siya nangyayari. Meron bang, pare, bibiliin ko yung bayad lupa mo, 1 million. Tama-tama, padre. Kasi bebenta ko talaga sa iyo to ng 1 million. So, sabi ng Supreme Court, valid. Kasi mayroong consent. May consent. Consent on the price, consent on the object. Ano yung property na binibenta at magkano ang consideration? Kaya valid daw. Pero kung itong sinasabi mo, there is no contract of sale, oral agreement lang. Ang talong, pwede mo mambawiin ang deposit. Natural, pwede mo mambawiin dahil wala namang kontrata. Kung sinala po yung title as collateral at nag-execute ng real estate mortgage, then the owner, di ba pwedeng isanla sa iba o ibenta sa iba na hindi alam nung una, pinagsanlaan niya. Correct. Kasi you have the right to sell it. Di ba? Kanina sinabi natin, bawal yung pactum dino aliende. Ito naman, retro de facto. Retro de facto, hindi po retro de facto. Retro, meaning repurchase. Facto de retro. Meaning agreement of repurchase. Hindi retro de facto. Facto de retro. Okay? So, pare, benta ko sa iyo to. 1 million. Kaya lang, bigyan mo ako ng 1 taon para biling ko muli. Pwede yun, back to the retro. Ngayon, kung hindi mo nabili, hindi mo na solo yung 1 million sa loob ng isang taon, ano nangyayari? Tuloy na ang bentahan. Kaya, pagka mayroon kayong back to the retro agreement, hindi pa yan subject sa capital gains tax or withholding tax, as the case may be. Bakit? The ownership is not yet absolute. Ang ownership hindi pa absolute. Ha? So, yan ang tatandaan nyo, ha, mga practitioner, mga broker. Huwag kayong mag-alala sa capital gains tax na hindi kayo makapagbayad sa loob ng 30 days. Because back to the retro is not yet absolute. Ibig sabihin, yung ownership is still hanging. The transfer of ownership is still hanging. Imagine, pag nirehistro mo yan, ililipat mo sa bumili, tapos after a year, ililipat mo na naman. Di costly. Oh. Kaya hindi po subject sa tax yan. Transfer tax. Oh, anti-recess. Ito naman, ang pinagkaiba nito sa mortgage, yung mortgage, binabayaran mo yung interest. Ito naman sa anti-recess, hindi mo binabayaran ang interest. But the interest is taken out from the fruits of the principal. So anti-recess is an agreement whereby the creditor takes the position of the immovable real estate of the debtor with the right to receive the fruits or rentals of the property. Then, obligation to apply them in payment. The interest, if any, of the loan extended by him and thereafter, the principal of the creditor, unless stipulated otherwise, the creditor is also obliged to pay the taxes and the charge upon the property and bear the expenses necessary for its preservation and repair. So, one of the important distinction between the two, in the contract of mortgage, there is no delivery of possession. There is no delivery of possession. In the contract of anti-crisis, there is a delivery. So there is a temporary turnover or transfer of possession from the debtor to the creditor. Kasi yung creditor, siyang magmamanage para siyang kumolekta ng rental at yung mga rental na nakuha niya, yun ay pababayad sa interest. And the excess shall be applied to the obligation or to the principal. Ang pagkakaiba niyan, isa pa, na yung mortgage, siya pa rin patuloy nagbabayad ng buwis, samantala itong anti-crisis, ang nagpautang siya magbabayad. Kumbaga, yung management of the building, of the property is temporarily transferred to the creditor. And the creditor obligation is to preserve the property because any fruits or rentals of that property shall be what? Charged to the interest and principal. So essential requisites of mortgage, of course, to secure the fulfillment of principal obligation. So security. Security. Attorney, paano po ma-force ang developer na i-transfer ng title sa buyer? Kasi 5 years na di pa nila transfer. Yan ang problema. So, pinakamahinam, punta muna kayo ng lisod, magreklamo kayo. Attorney, what's the best thing to do sa mga buyers in this case? Yung developer, pinasok most of the TCT sa pag-ibig. Fully paid buyers, ang mga naghuhulog ay nakapira na sa properties na nabili. Pero di pa nakapangalan sa kanila, only deed of sale. Yan po ang kadalasang problema ngayon. Marami mga ejectment cases. Pinay ang pag-ibig. Together with the so-called buyer under the program, pasalo program. Yan. particularly in Cavite area. Ang daming pasalo dyan. Pero hindi lang isang kaso, dalawang kaso. Tatlong hinawakan ko dyan. Palagi ako doon sa uh, first owner. Ayun, nadidismiss lang ang kaso. Kasi nga, tama, yung titulo, hindi pa nakapangalan sa pag-ibig, sa developer pa. Oh. Pero may deed of sale na. May deed of sale. Eh, pag nag-file ka ng kaso, ang korte, hindi yan binibigyan ng pansin. Ang nakalagay dyan, yung nakapangalan pa rin. Kasi pagkapag-ibig, ang first buyer, nililipat ng pangalan sa nakabili, first buyer. So, ganyan. Kung binili mo yan, pasalo, hindi ba ililipat kagad sa iyo yan? Ang iba naman, yung titulo, nasa developer pa lang. Kaya, kung kayo, broker, nagpupus kayo ng pasalo, ay na-discouraging pasalo. Kaya nga sabi ko doon sa pag-ibig lawyers, alam mo, this pag-ibig was enacted because of the obligation of the state. It is one of the social legislation of the state to give decent housing to the Filipino people. So, anong nangyari? Hindi na decent. Kundi, nagiging squatter na yung mga nakabili na hindi nakapagbayad, lalo na during the pandemic. Dami nangyaring ganyan. But anyway, we will not concentrate on that political issue kasi it's more on politika, hindi same. Kaya nga, okay lang yung mga nagbukan doon sa pasalo, pero hindi pa masyado sa atin ang batas doon sa pasalo. Kasi akala nilang pasalo ganun lang. Without considering the existing laws on law on mortgage, saka law on contracts. So, iba-iba. Pag nasunog ang bahay nakasanla at ang monthly installment ay up to date naman, di ba yung fire insurance process ay dapat ipagawa na nasunog na bahay to restore its collateral value. Remember that the improvement is only part of the entire collateral. The other part is not the lot. You know, sa insurance kasi, sa contract, there are different ways by which the contract is extinguished. The loss of the thing. So, if the improvement was lost, so there is already extinguishment of obligation. Why? There is already a loss. Diba? Of the thing. And what is the thing? The improvement. Yes, the lot is still there. The lot is still there. But remember, balikan natin, yung coverage in the entire improvement and the lot. O so nawala yung improvement, so hindi na yun nakasanla. Kaya nga, the property is insured. Yes, hindi pa bayad ang utang, pero dahil nasunog, total loss, then the proceeds will be now paid to the what? Creditor. Kasi ang beneficiary ng indemnity insurance or loss insurance, fire insurance rather, is the creditor. Yan. Tama po, lote na doon lang. Pero walang halaga yung lote kung walang improvement. Di ba, mga appraiser. Di ba? In fact, it's a matter of practice, mga bank loan managers, they will not approve the loan unless there is an improvement. Seldom. Unless, of course, DBP, development, industrial development. Or yun, dati DBP, Development Bank of the Philippines. Ayun, nagbibigay sila ng loan kahit walang improvement. Ano nangyari sa DBP? Ayun, ang dami nagpakamatay doon. Bakit nagpakamatay? Aba, yung nagnotaryo, yung nag-approve, Ayun pa ng sinasangla. Ha? Tubigan. Fish pan. I know that situation because I have a friend there working. Sabi niya, attorney, talagang grabe ang DBP. O, di ba? Kaya wala ang DBP. Attorney, what's the best thing to do sa mga buyers in this case? Yung developer, pinasok mo sa piece pag-ibig. Ayan. Sagutin natin. Paano ma-force? Okay. Reklamo, ha? Reklamo. The mortgagor should be the absolute owner. Oh. Absolute. Ibig sabihin, nakatitulo sa kanya. And not only that, hindi siya naked owner. Nakatitulo nga sa kanya, nakarehistro, but he has no control. So in other words, he's not the absolute owner. And the mortgagor should have predisposal. So magkakadikit itong absolute ownership sa predisposal. Because if you are just a registered owner or naked owner, you have no predisposal. Because there's somebody behind you. O yung mga dami kung tawagin. Ha? Yung natatago. When the principal obligation becomes due, the mortgage may be alienated to secure payment. So for the mortgage to be validly constituted and to prejudice third person, the mortgage should be recorded with the register of this. So those are the requisites of a valid mortgage. Oh. So mortgage may be characterized as all embracing, inseparable, and indivisible. So, di ba sabi natin kanina, ang coverage, lahatan, kalahatan. Because it embrace, it's separate, inseparable, and indivisible. Kahit sabihin mo na iba-ibang titulo, iisa pa rin ang turing sa kanila. So, mortgage is interest in land created by a written instrument providing security for the performance of the duty or payment of a debt. The mortgage extends to natural accession. So, isang hektarya ang sinanla mo. Ha? Then hindi ka nakapagbayad na foreclose. Noong nagpa-resurvey ka, hindi pala hindi pala isang hektarya ang sinanla mo. Masigit pa doon ang tanong. Yung sobra ba? Kunyari, isang hektarya ang sinanla mo. Pero lumalabas na 1.5 hectares pa lang. Pwede mo ba kunin yung sobra na kalahating hektarya? Yan ang tanong. Ha? The answer is no. Because it is all embracing, inseparable, and indivisible. Ha? Kasi yung property mismo, ang sinanla mo without regard to the actual area. Oh. Kung mayroon mang continuous gradual deposit of soil and expand the area, then that expanded area is also part of the principal. So encompassing lahat, embracing. Hindi pwede, isang hektarya lang ang collateral ko, yung sobra akin. Hindi po ganun. Lahat. Growing pros and rentals or income not received when the obligation becomes due, and to the amount of indemnity granted or owing to the proprietor from the insurer of property mortgage or by virtue of expropriation for public use. With the declaration and clarification limitation established whether the state remains in possession of mortgagor or passes in the hands of the third person. So wala po, package po yun. Walang sobra, walang susulit. Kasi nga, lump sum yan eh. Ayan o. Is the deed of mortgage valid even if it is written in a private document? Ibig sabihin, hindi notaryado. Nakasulat na, pero hindi notaryado. Valid ba yan? Well, valid yan. Yes, it is perfectly valid between the mortgagor and the mortgagee. And it may also bind the third person if the latter has actual knowledge of such mortgage agreement. Because actual knowledge is equivalent to registration. Yan ang sinasabi ko sa inyo kanina. Kahit hindi naka-annotate sa titulo, as long as you have the actual knowledge of the fact of mortgage, then you are bind. You are bound by that knowledge. Ha? Hindi mo pwedeng bilhin yan kasi nakasanla. Pag binili mo yan, ang katwiran mo, hindi naka-annotate, that is not acceptable reason of defense. Okay. Could you assign the mortgage credit? Yan. Ito mortgage credit. Can you assign the mortgage credit? Sino nag-a-assign nito? Yung nagpautang. Yung lender. Okay. Ang tawag dito ay subrogation. Yes, the mortgage credit may be assigned in whole or in part, provided notice may be served. Creditor and the assignment need to be registered to affected person. So we are talking about subrogation and novation. Why? If you are the borrower, if you want to transfer your credit, your loan, to somebody else, you cannot do it alone. There must be consent coming from the creditor. Otherwise, the new borrower has nothing to do with that agreement. The old contract of mortgage. Kaya, kung mapapansin nyo, di ba? Okay, balik tayo sa real estate. Di ba, under the Maceda law, one of your rights under Maceda law is to transfer, to assign your right over the property. Pagka hindi ka na makapagpatuloy. That is allowed. Under Maceda law, that's one of your right, being the buyer. You have the right to transfer or assign the right to third person. But the question is, can you do it alone? Yes, it is allowed under Maceda law. Yet, you have to refer it also to the general contract or the civil law. Because that is not binding to the developer. In order to bind the developer, you must get the consent of the developer. Di ba? Kasi nga, i-assign mo. Anong reason? Bakit kailangan ng consent ng creditor, yung nagpahiram kayo? Because of the capacity of the new borrower. The creditor wanted to know the status, the insolvency or solvency of the new debtor. Ikaw nga, insolvent ka na. Kukuha pa ka ng another insolvent. Ay, paano mababayaran ng utang? So, the creditor must be notified. Yun po, Okay. So, there is such thing as novation. Novation because the party has changed. So, the characteristic, the personality of the debtor has been changed. So, nagkaroon ng new debtor. So, pagka nagkaroon ng new debtor, there must be prior consent from the creditor. Okay. Ibalik na rin naman natin. Pwede ba ilipat ng creditor yung pautang sa ibang nagpapautang? In other words, can bank, the lending bank, transfer its right to another lending institution or bank? The answer is yes. Even without the consent of the borrower. Kaya magugulat ka na lang, pinapadala ka ng demand letter ng ibang bangko o ng financing institution. Kunyari, umutang ka sa Bank A. Tapos, ang sumunod na sulat sa iyo, oy, magbayad ka. Pero ang nagpadala ng sulat ng demand letter, Bank B. Ay, hindi mo na ako magbabayad dyan dahil may utang ako kay Bank A. Wala akong utang kay Bank B. Ay, hindi pwede. Kahit walang consent, yung creditor, they are allowed. Ang tawag doon, subrogation. The rights of the old creditor has been already transferred and subrogated to the new creditor. Tulad nangyayari ngayon, yung mga combination, merger of banks. Yung isang bangko, dati, tulad ng halimbawa ng UCPB, ngayon wala ng UCPB. All transactions pertaining to UCPB must be coursed through to the land bank. Kaya ikaw ngayon, may utang ka sa UCPB, Carlo, pinadalang ka ng Land Bank of the Philippines. Magre-reklamo ka? Hindi po. Because transfer of mortgage credit by the creditor to another creditor, even without the knowledge or consent, coming from the debtor is allowed. But, on the other hand, the transfer of mortgage loan from the old borrower to the new debtor or borrower cannot be done unless with prior consent from the creditor. Ang tawag doon, novation, change of new debtor. Tandaan nyo yan, Subrogation, pagka-creditor nagpalit. Novation, pag nagpalit ang creditor. Sa subrogation, walang consent ang may utang. Pero sa novation, nagpalit ng magbabayad ng utang, kailangan mayroong prior consent yung creditor. What happened to the remainder of the mortgage if the insurer would get the proceeds of the fire insurance claim? Fully paid na ba ang loan? Well, it depends. You know, sa insurance, meron tinatawag ng over-insurance. You cannot insure above the insurable interest. For all you know, I've been also an insurance underwriter, both life and non-life, prior of becoming a real estate broker. Because generally speaking, insurance is only to insure losses, indemnify losses, not to make profit out of loss. Kaya nga, ang value ng property mo, 100 million, in-insure mo ng 200 million. So, total loss. Don't you think makukuha mo yung 200 million? You cannot. You cannot. Because there is an over-insurance. If there is an over-insurance, you get only the worth of the actual loss at the time of the incident, not at the time of the execution of the contract of insurance, but at the time of loss. Maraming mong ganyan. Kaya ang kadalasang kausap nyo dyan, yung mga adjuster. Insurance adjuster. You know, once upon a time, I'm a friend of one of the insurance commission. It's a lady commissioner. Kaya lang, parang ang istorya niya parang Lady Diana. O ngayon, mag-research kayo kung sino yung Lady Diana of Insurance Commission. Pero it's nice to study also fire insurance or insurance. Kasi pag nasa real estate ka, nakikita ko sa Facebook, maraming mga real estate broker. They are also in real estate, in insurance business. Okay. Attorney, pwede ba i-deed of donation na ng parents yung property niya kahit na may anak pa siyang na minor? Gusto kasi niya masiguro na proportion ng pagkahati ng property niya. Baka daw manglamang ang makakadagla. Aba, mukhang sinasamantala niyo ha. Mukhang, di ba? Sige, sagutin natin. Ha? Well, may epekto yan. In the first place, ba't kayo magdo-donate sa minor, sa anak niyo? Ha? Sinong tatanggap? May kakayahan ba ang minor tumanggap ng donation? Wala. Pero kung galing sa ibang tao, pwede tumanggap ang minor ng donation because you will act as guardian of your minor child. But you have to go to court to ask for court approval to be the guardian of the minor when it comes to management acceptance of donation. Remember, donation must be accepted. Kasi gusto niya masiguro na proportion ng pagkakahati ng property niya. Baka daw manglamang ang mga nakakaganda. You are talking about estate planning. O yun, isa rin yan. Deed of donation. Di ba? Yung mga planner, yung mga insurance advisor. Yan, mga pinopropose nila. So at the end, you will be advised ng mga financial planner to buy an endowment plan. Sinabing insurance endowment plan, you get the discounted, the present value of that insurance endowment plan, ibibigay mo sa mga anak mo. Irrevocable beneficiary. Yun, isa yun. That's how you would transfer your property to your minor child. By making your minor child the irrevocable beneficiary. So kahit bata pa siya, okay na. Yung pang ginagawa ng iba. Okay, sa tao lang ang usapan, magbayad at nagsanla ng 3%. Pero 10 years na di pa nagbabayad, promise na ng promise, ano magandang gawin? Mamaya, pag-uusapan natin yan. Tapos na tayo rito, ha? Okay, so anong procedure when you enter a contract of mortgage? Execute the document, go to the notary public, so hindi mandatory. Kaya lang, kung gusto nyo maging registerable, pwede kayong pumunta ng notary public para inotaryo. Pay the doc stamp kung gusto nyo i-register ang date of mortgage. Alam nyo naman, it could not be registered unless you pay the corresponding doc stamp. O di ba? Ang doc stamp ata ngayon, 200 pesos. I think 10. 40. The first 200. 200 ba? 5,000. I see. 5,000. First 5,000. 40 pesos. Then succeeding 5,020. So may doc stamp. Kaya yung iba, usapang utang na lang. Bigay sa kanya yung collateral na titulo, hindi na-re-registro. Kasi mayroong doc stamp eh. Hindi na nila kinuha, hindi na rin-register. Kasi pag ni-register mo yan, bukod sa doc stamp, magbabayad ka sa biyaya, pupunta ka pa sa register of deeds. At magbabayad ka ng registration fee. But that's how to secure your debt, your loan, extended to the borrower, to the owner of the property. Kasi kung verbal lang, o kaya may kasulatan man kayo, hindi notaryado, notaryado pero hindi kayo nagbayad ng doc stamp, hindi nyo mariregister sa register of deeds. So, pag hindi nyo narehistro, so walang annotation. Kaya, kung kayo ang nagpahiram, pamukat-mukat nyo, yung property na ibenta na. Alam mo, simple lang gagawin nila. yung nangutang, idideklarang lost title. Ikaw naman, nagpupunta ka sa abroad, hindi ka na nakapaningil. Kaya umabot ng 10 taon, hindi ka pa napaningil. Pagbalik mo ng Manila, iba na ang nakatira, nailipat na. Ang tanong, may habol ka ba? Wala na. Kasi nailipat na. Hindi mo na rehistro ang mortgage. So, yun ang kababayaan mo. Wala ka ng habol. Oh, what is the effect of the invalidity of mortgage contract to the principal obligation? Natatandaan nyo, sinabi ko kanina, dalawang bagay na pwedeng maging walang visa ang contract of mortgage. Mayroong isang provision, mayroong kontrata na nakapaloob na bawal ibenta. Ha? Pactum din na agende. At yung pangalawa, yung pactum commissorio. So, yun ang mga provision na pinagbabawal ng batas. So, void ang contract. Pero anong epektibo? Anong epekto niyan sa loan obligation, sa loan, contract of loan? So, the contract of loan remains valid. So, the mortgage then remains an evidence of principal obligation. Kahit na void, yung contract of mortgage, pero ebidensya pa rin yan ng utang. Halimbawa, ang isang kumpare mo, pinagbigyan mo ng loan, tapos gumawa ng contract of loan, I promise to pay you in the amount of 100,000 on or before the end of the year. Sign. So, pirmado. Naiwala mo yung promissory note. Nag-inuman pala kayo ng kumpare mo. Nakita niya nalaglag sa kubeta. Nayaan niya na lang malaglag at nilagay pa niya, i-flash niya. Oh. Diba? O ngayon, sinisingal siya ng kumpare niya. Pare, parang nalasing ata ako. Alam ko, meron kang utang 100,000. Pare, wala akong utang. Ngayon, kung may utang ako, pakitaan mo ako ng dokumento na may utang ako sa'yo. O yung kumpare, alam niya na wala kasi na-flash niya sa inodoro. May masmasan. Pare, bukod pala sa promissory note mo, mayroon kang binigay sa aking titulo. Ha? Paano napunta sa akin itong titulo? May nireceive ako sa iyo. Ito, collateral. Doon sa utang mo. Ito, mayroong gano'n. Pag hindi ka nakapagbayad, ito, ibebenta ko. Akin na. Although that contract is void because it contains a prohibitory stipulation, yet that is an evidence of principal obligation. Parang may utang ka pa sa akin, hindi ko pa nasusuli sa iyo yung pinirmahan mong mortgage contract. Yan. Kaya wala kang luto. Okay. So, aside from that, it creates real right. So, if the mortgage sells the encumbered property, the property remains subject to the fulfillment of the principal obligation secured by. Kahit na ibenta yan ng utang, mananatili pa rin yan security. Kaya, as a seller, as a buyer, you should examine the title. Kung may sangla o wala. Kasi nga, kung may sangla yan, pinorclose, di nabayaran, sorry ka na lang. You are bound by that contract of mortgage. Kaya di ba tayo mga broker, ang ating palaging kinukuha bago tayo bumili, i-advise natin yung ating kliyente na bumili, we secure first a certified true copy. Tinitingnan natin kung may encumbrance, especially if there is an existing loan. Nakalagay yung loan. Annotation, entry number, contract or real estate mortgage, in the amount of 100,000 executed on, ganyan, notarized by. So until the action for expropriation has been completed, ownership over the property remains with the registered owner. So habang existing ang loan at walang foreclosure at di pa nililipat ang pangalan sa nagpautang, anuman ang fruits, kung na-expropriate man yan, ang kabayaran niyan, mapupunta sa registered owner. Therefore, banking institution must exercise due diligence before entering into a contract of mortgage. I filed a case for cancellation of contract of mortgage and annulment of foreclosure. Kasi nga, ang katwiran, the banking institution must exercise due diligence. In fact, the due diligence required for a bank is not ordinary diligence, but extraordinary diligence. Mas higit pa po ang diligence na dapat gampanan ng bangko as compared to ordinary people. Kung lay person yan, ordinary person, ordinary diligence lang. Just an exercise of being a good father of the family. So, by mere looking on the title, there is no encumbrance, that's it. That's already compliance of exercise of due diligence. However, for a banking institution, that is not the only thing that you have to do. Because the bank should exert more mileage, extra effort to determine whether really the ownership of that property, remember, the ownership must be absolute. The mortgagee, the mortgager must have the predisposal of the property. Doon sa isang kliyente ko, nag-submit ng marriage contract. Ang katwiran, in-apply ng loan, nirelease ng bangko. DBP. Yun nga. Nirelease ng DBP, 10 million. And because of that, binay out, binayaran ng isang private bank, yung utang, yung outstanding loan ng registered owner. Ngayon, nung binay out, 15 million ang bagong utang sa bagong bangko. So binayaran ng first bank, ang katwiran nila, they have already exercised diligence because the first bank who extended loan already exercised the required diligence for a banking institution. But I found out that the marriage contract submitted by the mortgagor is what? At the time of the alleged deed of donation, because the property was allegedly donated to spouses by the original owner. But when I look up at the old title, the cancelled title, because it was cancelled by virtue of deed of donation, at the time of donation, the mortgagor is not yet married to the son of the original owner. Because at that time, she was only 15 years old. Even on the assumption that they are married, yet the marriage contract is void. Because it was solemnized when the girl is only a minor. Yun, ay sasaya sa mga due diligence. Yung birth certificate, yung marriage contract. Tingnan nyo. Ayun, ano pala kabinbin? Kasi nagbitaw ako nag-withdraw ako ng appearance kasi malayo nga. Tapos nag-pandemic. Sa San Carlos City. May client is well-known family in San Carlos. Ayun. Ano ngayon? Nakabinbin. Aywan ko kung ano nangyari. Pero sigurado matatalo yung bangko. Kasi yung marriage contract na pinagbatayan na married, at the time of donation, they were not yet married. Kaya mag-iingat kayo sa mga donated property, ha? Kaya mga broker, advice ko lang sa inyo. Okay lang yung mga mana, kasi nakalagay yung section 474. Pero yung donated property, kaya mag-trace ba kayo? Attorney, since the creditor does not need the consent of the borrower, if he wants to transfer the mortgage to another creditor, what is the protection of the borrower that this is not false info or just anyone making claims? Should the borrower at least be provided with notice or a letter informing the transfer of creditor to another bank? Of course, as a matter of procedure, the new banking institution or the one handling now your loan will give you notice that this is the new loan officer that will give you ganyan. Meron din sila. Pero yung pag-transfer ng loan, na sila na, hindi po ginagawa yan. Makakatanggap ka lang ng sulat kung paalalahanan ka o magbayad ka. Kasi the loan, the PN number, the promissory note number is the same. Katulad ng bawa, yung UCPB. Ako may pending case ako sa UCPB. O ngayon, alam na ang UCPB na effective this date, ganito, ang bago na ang dependent. Land bank na. Ganon. Pero yung palalahanan kayo, ililipat namin ang utang nyo, ha? Hindi ganon. Hindi na kailangan. Attorney, mas okay po ba deed of donation or deed of sale? If ibibigay ng parents para na po habulin, hindi na po mahabol ng mga kapatid. Buhay pa po ang parents. Alam nyo, you better decide. You better choose. Kung mahal nyo ang anak nyo, bigay nyo sa anak nyo. Okay. Donation. Kaya lang, pag nawala kayo sa mundo, hahabulin ng mga kapatid. Kasi donation. Hahabulin. Ang tawag doon ay advanced inheritance. So magkakaroon ng collation. That's number 1. Number 2, so magkikreate ng tampuhan, inggitan. Kung deed of sale naman, hindi na nga mahabol ng mga kapatid niya. Kasi nga, bentahan. Kaya lang, kung may asawa yan, di bahagi na yan ng asawa, hindi na exclusive, magiging common. So, you choose. Kasi isa ngayon, under the train law, pare-pareho na 6%. In fact, mas mura nga ang donation kasi minus 250 as an exemption. So, you save 15,000 in the form of tax. Kaya na, may mga komplikasyon yan pagdating sa right of ownership. So really, you have to sit down among your siblings, among your parents, and discuss how it will be good. Ang iba naman, instead of transferring that directly to the children, they form a corporation. Lalo ngayon, sa new corporation code, ad infinitum ang buhay ng korporasyon. Patay na yung mga incorporators, walang kamatayan ang korporasyon. Hindi katulad dati, hanggang 50 years and renewable for another 50 years. But now, wala nang kamatayan ng korporasyon ngayon. Hanggang hindi nilalagay sa Articles of Incorporation ang period of existence. Pag blanco ang existence ad infinitum, walang kamatayan. Attorney, may ask po, paano mag-apply ng title na rights lang ang hawak? O di mag-apply ka. O maraming paraan. Residential land patent under Republic Act 10,063. Pag-residential. Pag agricultural patent naman, pre-patent, wala na. You have to apply for judicial titling. Judicial. Through adverse possession. Attorney, question po, ang utang ba o mortgage ng husband na namatay, mamanahin ng asawa? Yes, mamanahin kung mayroong property na iwan. Pero kung utang lang na iwan, hindi mamanahin ng utang. Ang minamana yung properties. But the obligation existing at the time of death should be reduced. should be deducted from the properties of the decedent. Oh, may batas po na dapat pagbayad ng utang. Pero, kung may pambayad ang namatay, hindi po siya magbabayad, kundi ang magbabayad yung ari-arian niya nung siya'y nabubuhay pa. If loan annotated in the title 50 years ago, will it be still hold as existing loan within release of loan? Well, meron po tayong tinatawag na prescriptive period. Anong mang bagay na karapatan at hindi mo ginawa at tinulugan mo, ang sabi niya, natulog ka sa kampungan o sa pansitan. Siyempre, kababayaan mo, you lost your right by prescription. Or by negligence. Paano ba yung bayad ng owner, yung property, pero sa developer name ng title? Kasi wala pang pera, pang transfer yung owner. Okay lang ba ipatransfer niya sa name? Pangalan ng pamangkin niya as donation po. Lalong hindi mo magagawa yan. Remember, you must be the absolute owner. Hindi naman kayo absolute owner. Wala pa nga sa inyong titulo. Paano nyo i-donate sa pamangkin nyo? Oh. So may problema. You better update your title. Mana attorney, pero transferred already during married na po. May karapatan bang asawa? Pagka inheritance, walang karapatan ng asawa. Kasi exclusive property. Walang karapatan. Mayroong karapatan na lang yan kung namatay yung asawa bilang one of the compulsory heir. There is no promissory note made in a mortgage agreement. There is no such thing as mortgage agreement na walang promissory note. Because the promissory note is the contract of loan. That is the principal obligation. Principal contract. There is no mortgage contract if there is no contract of loan. Is the mortgage valid? Definitely not valid. Walang contract of loan eh. Dapat may contract of loan muna bago magkaroon ng contract of mortgage. Paano yung bayad na sa donation na transfer na sa kanyang tax declaration? Ay pwede mo magabon mga kapatid? Well, it depends on the facts of the case. Pwede siguro. Pero right now, I could say, pwede. Kasi donation lang eh. Pwede magkaroon ng annulment of donation. Because of what? In officio donation. Hindi naman totally avoid yung donation, but portion of the property will be considered void. Because if it is in officio, dahil ang kapatid, bilang compulsory niyang magulang, katulad mo rin kapatid, so may karapatan sila. Depende yun. Attorney question, totoo ba 50 years lang ang kondo po? Well, under the law, under Public Act 476, the Condominium Act, nakalagay doon 50 years, another 50 years. But it doesn't mean that after 100 years, you are no longer there. So still, you are part or co-owner of that condo unit, condo project. Kasi as unit owner, you have common ownership on the common areas. Kung nilindol, and it is not already susceptible, or rather is not already habitable, so it will be demolished. So there is certain requirement in order that this condominium will be demolished or not. So, in fact, you need at least, I think, 3/4 vote of the condo owners. But if it is a repair, only majority. Attorney, currently nasa mother title. Nagbenta si seller ng blood. Na-transfer yung naibili, pero napabayaan yung remaining land at hindi naiwalay sa mother title. Ano po ang magandang remedy doon? Kasi may mga nakabiling bago, portion na lang, pero hindi nila mailipat kasi kailangan daw may irregular title na ang remaining lot. Well, ang kailangan nyo, magpakuwang kayo. Pagpa-relocation survey. Meron ganyan. Relocation survey, so yung mga hindi pa nailipat, so common pa yun, nandun pa sa mother title. So, yun ang i-parcel nyo na. So, relocation survey, then you execute a deed of partition. Hindi na kailangan na pumunta sa husgado kasi that is already titled property. All you have to do is to secure the services of a geodetic engineer. Then, the moment the geodetic engineer had already prepared the survey, the relocation survey, so there will be apportionment or partition among the person who bought the property, which is not yet transferred to their name. So they will execute a deed of partition. So yun, ang ita-transfer nyo, i-register nyo sa Register of Deeds. And of course, you have to pay. Kung nabili yan, so you have to submit documents evidencing the transfer of ownership by way of sale. Ang problema dyan, baka hindi nyo na-transfer, hindi nyo nabayaran yung capital gains tax or withholding tax, as the case may be, malaking babayaran nyo kasi may penalty. Kaya, as a better sa broker, the best thing to do is that kahit hindi pa napaparte-parte, bayaran nyo na ang corresponding capital gains tax or withholding tax, as the case may be, within the period provided for by law. Otherwise, you will be penalized, subject to interest. Yan ang problema ng iba. Paano applyan ang title na coastal area? Siguro we are talking about ano yan? Hindi ko forest area, forest land, o you're talking about the beachfront, salvage area. Marami pong ganyan. Yung salvage area near the beach, hindi pwedeng patituluhan. Pero pag napatitulan, because of some scrupulous personnel of DNR, kasi galing yan sa DNR eh. Siguro, sinasabi niyo portion land siguro. Hindi pwedeng patituluhan ang portion land. You can list that portion land for 25 years. Then renewable for another 25 years. Portion land, the area near the sea. Normally, ginagamit ito mga palaisdaan. Kailan po mag-juduli ang amnesty? June 14, 2023. At infinitum na din po ba ang mga domestic corporation? Yes, automatically. If you did not change the period of existence. Yung mga existing at the time of the existing corporation at the time of the passage of the new corporation code, automatically, by operation of law, ad infinitum. So you have to declare the period. You have to make communication. You write a letter of communication to the SEC that you are maintaining the period of existence as stated in the article of incorporation. Otherwise, it will be ad infinitum. Binili ang lupa nila, pinalipat, pinatira sa ibang lupa, bumili ng lupa. Pwede ba sila mag-demand, may pa-title? Well, there is a manner for that. Pinagbayad sila ng buwis yearly. O maganda ngayon, nagbabayad kayo ng buwis. O at least, you can now say that you have exercised your right of ownership. Pwede ba gamit ang judicial means as mode of transfer from tax declaration to original title? Well, you can do that by filing a specific performance depending on the actual case, on the facts of the case. Because There are cases na hindi ayaw sulit sa inyo, ayaw i-turn over mga dokumento, so you cannot transfer ownership because it is being delayed because it hinges on the documents already still in hand or on hand of the seller. So you have to compel the seller. Kunyari, nabili nyo na ayaw i-turn over ang owner's duplicate kasi nangako. O, magbayaran na tayo. Eh, paano yung owner's duplicate? Pasensya ka na. Kasi nandun sa vault. Hindi ko pa dala susi. Eh, bukas sa Lunes na lang. Pwede ba yun? Ikaw naman, kasi gusto mong property, napaniwala ka, binayaran mo, nag-execute ka ng deed of sale, oh. Pero hindi na ibigay sa iyo ang owner's duplicate. So, hindi mo mailipat. Hanggang pinagpabukas-bukas ka o ano gagawin mo, you have to file a specific performance. Alam nyo, may modus yan. I already come across with that kind of modus operandi. By a certain professional. Nung araw kasi, di ba, hindi pa masyado ka yung resa law. Eh, wala yan, attorney, yung resa-resa. Pwede mo na akong maging ahente, broker, kahit wala akong lisensya. Ganun ba? Tapos nagkaroon ako ng kliyente, siya pala ang namibiktima. Ikaw pala engineer. Buti ako na naging abogado ng kalaban mo, kung hindi, pakukulong kita. Nakiusap sa akin, inareglo. Yun, doon ako natuto, ganun pala. Marami pong tayong hindi pa alam minsan. Minsan ang ibang mga kolorong ay yung pang magagaling. Ito, forest land. Ayan sinasabi mo. Forest land. Stewardship. Pwede po. Kaya na ngayon, ang alam ko, ang DNR, hindi nagbibigay ng stewardship. Nakabinbinata. Mayroon silang moratorium. Bawal muna ngayon tumanggap ng stewardship. 25 years din ng stewardship. Ito mga forest land to. Pero you cannot apply for stewardship yung mga forest, yung mga reserve area. Mga watershed. Reserve area. Agricultural lot with annotation of notice to proceed. Date, July 17 by DAR. Compulsory acquisition, enforceable. Since well, kung awarded na ito, tuloy-tuloy naman. Wala namang pinag-usapan. Yung voluntary acquisition, compulsory acquisition ng DA alang DAR, tapos na. Pero yung processing of award, tuloy-tuloy. Ano po ba ang ancestral domain? Yung ancestral domain, para sa IP. IP, indigenous people. Yung ancestral domain. Yan. Basahin niyo yung Republic Act 8371. That is the organic law or the law pertaining to ancestral domain. Pero, tingnan nyo rin itong ancestral domain, that is not registrable. Hindi nyo pwedeng ibenta yan, ancestral domain. Maraming ganyan. I have a case, sa Mindanao. Yung ginawa sa DAR. Binigyan sila ng CLOA, 100,000 hectares. Region 10, 50,000, another 50,000. Tapos sabi ng mga taga CIP, yung National Commission on IP, pwede kayo magpatitulo. So, in-apply yung CART, yung 3 hectares. Napatituluhan, kanya-kanya. Siyempre, pag napatituluhan, natural. Nasa tax mapping na yan, ng lokal na pamahalaan. At siyempre, mayroon ng tax take yan. Pag hindi kayo pagbayad, ipupurpit. Pag napurpit, mapupunta sa LGU. Sabi nung kliyente kong dato, alam niyo, mali ito. Maling-mali. Hindi dapat patituluhan ang ancestral domain. Tama rin. Bakit? The moment na pinatituluhan yan, hindi na ancestral domain yan. Private property na yan. Ito. For all you know, I am also a lawyer of IP. Alam ko to because marami akong pinuntahan. Alam ko ang mga IPs. Sierra Madre, Mindanao, Saya. Yan. Share my aunt is single and 75 years old. What happens to property under their name? When she passes away, di ma-inherit yan ng mga kamag-anak. I'm concerned because most of this property are commonly owned among your siblings. Legally, who will inherit the property? Di yung kapatid. Pag walang kapatid, pamangkin. Pag walang pamangkin, di anak ng pamangkin. O di, apply the succession law. The nearest excludes the farthest. Ano ba yung buyer yung mortgage binayaran private institution? At binayaran niya sa kanya, pero bayaran po close na dito buyer. Oh. Okay. So, siguro, puntahan muna natin yung slides, okay? Okay. Para ma-cover natin lahat. It creates a real right. Okay. So, until actual expropriation na discuss natin, Chris Merlin encumbrance. Okay? Is there a need to register deed of mortgage? Yes. In order to buy third person. Yes. Yan. The purpose of registration, to assure you that you are protected. What's the procedure of mortgage? Of course, registered by filing register of deeds, brief memorandum, yung entry. Encumbrance. So, alam nyo na yung lien. Encumbrance. So, encumbrance is anything that impairs the use or transfer property. Anything which constitutes a burden title, a burden shares upon the property. So, you can compare encumbrance and lien. Lien meaning it's money. Encumbrance, it refers to anything that restricts, controls the use of property. So, mortgage also restricts the use. Not restricts the use. Kundi, it's subject to charge. Kaya, monetary lien. Mortgage, so governed by Rule 68. If you want to have a judicial foreclosure, and 3135, yung extrajudicial foreclosure. Ito ang madalas ginagamit ng bangko, yung extrajudicial foreclosure. Misnomer itong extrajudicial foreclosure because really, you cannot foreclose property without going to the court. But the difference between judicial foreclosure and extrajudicial, in judicial foreclosure of mortgage under Rule 68, you have to present evidence. And there is a regular hearing before a decision is arrived. So you have to present evidence. So there is an opposing party, the plaintiff and the defendant. And the plaintiff is the mortgagor, yung umutang. I'm sorry. Ang pinautangan, yung pinagkakautangan. Hindi nagbayad. So, how could you foreclose the property? So, you have first to prove the loan na hindi nabayaran. Then, before you foreclose the property. Kaya may decision muna ang court. Pero itong extrajudicial, pupunta ka naman sa court, but not through the regular court. Through the ex officio sheriff of the regional trial court where the property is located. So there is no more hearing. Wala nang hearing, presentation of documents lang. No hearing. Kaya nga extrajudicial. And this is the most easiest way. Kaya yung mga bangko, pag umutang ka, mayroon kang contract of loan, mayroon kang contract of mortgage, mayroon ka pang pipirmahan na special power of attorney, allowing the mortgagee to sell through public auction without the SPA, allowing the mortgagee to sell the property in case of default through public auction, there is no valid extrajudicial foreclosure. In fact, this is my case in Sorsogon where I filed annulment of foreclosure proceedings, extrajudicial foreclosure. It's pending, and there is a pending settlement. Nangutang lang ng 2 milyon, naging 6 na milyon. Pinakapagbayad na sila ng almost 2 milyon. nag-pandemic, hindi nakapagbayad. So, pinapirma sila ng agreement na sila ay may utang daw na 6.5 million. Pumirma naman, siyempre, out of pressure. Hindi na alam ang gagawin dahil hindi naman sila abogado, seaman. Maganda yung lugar sa likod ng Kapitolyo ng Sorsogon. I think the market value now is almost 8 million. Ang utang lang nila 2 million. Ngayon, nag-file ako ng annulment of foreclosure. Kasi walang SPA. Kasi yung SPA, nandun sa original deed of mortgage. At question ko rin yung deed of mortgage because mayroon nga sinasabi ko na pactum dino legende. Kasi may provision doon na hindi pwedeng ibenta. Sinama kasi ang sale. Cannot sell, transfer, etc. Mortgage. So, yun pa lang, void na yun. So, wala nang contract of mortgage. Lalo na may pinapirmahan pa na wala namang contract of loan. So, bogus. If the mortgage has not been paid, what action should the mortgagee do? Ayan. So, the mortgagee, ikaw, may pautang ka, hindi ka binayaran, balasubas yung umutang. The mortgagee may resort to extrajudicial foreclosure only when a special power of attorney is provided in the original contract. Mortgage, authorizing the mortgagee to sell the mortgage property through public auction with the procedure prescribed under Act 3135 as amended by Act 4110. Ha? Kaya yung bangko, palagi man ganyan. Mayroong naka-form na yan. Ha? Detalyado na yan, nandun yung provision. Yung SPA. Ha? Kasi kung walang SPA, authorizing the bank to sell the property through public auction, you cannot do extrajudicial foreclosure. And the way to foreclose that is through judicial, under Rule 68. Matagal. Kaya nga nire-resort nila yung extrajudicial. Oh. If not, did the mortgagee resort to judicial foreclosure, whereby he files a complaint with the proper court, which after order hearing, orders the mortgagee to pay the obligation within 90 days thereafter. Should the mortgagee fail to do so, the court ordered the sale of the subject property in public auction, and the sheriff issues a certificate of sale to the winning bidder and confirms the sale. The mortgagee pays the balance, the obligation, the proceeds of sale is not sufficient, execution follows thereafter. Okay. Para to cut the provision short, understandable by you, no? Pagka extrajudicial, walang hearing. Ha? Walang hearing. Pero kailangan mayroong SPA. Pag sinampay yan sa husgado, ang sheriff, through the clerk of court or regional trial court, will issue a notice of auction. I-assign niyo sa sheriff, at ang sheriff na yan, magpapadala ngayon ng notice kung kailan gagawa o kailan isasagawa ang public auction. Hindi na kailangan sumagot ang may-ari o yung umutang. Ang sagot na lang dyan, pwede siya pumunta doon, mag-participate siya during the public auction. Wala pong failure of bidding dito. Wala pong failure of auction. Why? Automatically, pag walang bidder, the highest bidder will be the mortgagee. Pag wala nag-participate, hindi failure of bidding. Kasi automatically, the mortgagee is already an automatic bidder. Together with the owner. So, dalawa na sila kaagad. Bakit? O pag hindi nag-bid ang may-ari, o yung highest bidder, yung nagpautang. O, kaya ang bid niya, yung amount ng claim. Yan, yun po ang extrajudicial. Mabilis. Pero yung judicial foreclosure, magkakaroon pa ng hearing. At kung kailan naging final, yung decision ng korte, doon pa lang magkakaroon ng order of auction. Kaya as compared Doon sa dalawa, ang pinakamaina, pinaka-shortcut, ang extrajudicial, mabilis. Kasi ang judicial, hanggang Supreme Court pa yan. Ha? Kaya they don't want to resort to judicial foreclosure. Kasi matagal, time-consuming, saka costly. Siyempre, kukuha ka ng abogado. Samantala extrajudicial, wala. Hindi na kailangan ng abogado. Okay. May utang. Di nakapagbayad, na-foreclose. Yan ang remedy ng nagpautang, foreclosure. Either extrajudicial or judicial foreclosure. Ha? Okay. Kung na-foreclose, anong remedy ngayon ng umutang? The right to redeem. So, right of redemption is a real right. It could be subject of sale. It could be subject of transfer or contract. Ha? Kaya, pwede nyo pagpraktisan to na maghanap ng right of redemption. Bakit? Dito kayo kikita, instead of commission, pwede kayo magkaroon ng kita. Bakit? May puhunan kayo, you acquire the right of redemption. Paano? So, if it is a extrajudicial foreclosure, so you have the right to redeem within 1 year. Kailan bibilangin ng right? Yung 1 year from foreclosure. It's not from the date of auction. It's not from the date of auction. But from the date of registration of the sheriff's certificate of sale. Ngayon, halimbawa, alas 3, nagkaroon ng auction, nanalo yung creditor, yung nagpautang. Siyempre, hindi naman magagawa kagad ang certificate of sale niya ng sheriff. Dahil ngayong Biyernes, maaaring next week pa. Siyempre, prepare pa mga documentation. So, doon pa lang magbibilang ang 1 year. Pero, kung kayo ang nagpautang, bantayan nyo ang register of dates. Bakit? Kahit na yan, dinala ng sheriff, doon sa register of dates, tinatakan niya ng receipt. That is not the counting of date of 1 year, but the date of annotation. Paano ka kautsaba yung clerk, yung receiving clerk? Ha? Yung receipt. Tapos, pinatungan ng pinatungan. Hindi na pa-annotate hanggang inabot ang 1 year. Akala mo, tapos na yung 1 year. But you did not get a certified true copy. Na to assure you that the certificate of sale issued in your favor by the sheriff was already annotated or recorded. Because the word recording is the annotation. It's not the stamp receipt of the clerk, receiving clerk of the ROD. It's the annotation in the title itself. Kaya as a matter of practice, you have to go back a week after submission of the certificate of the sheriff sale. Balikan nyo at kumuha kayo ng certified true copy. Baka walang nakatatak din. Nagbibilang kayo ng 1 year, wala pala nakatatak. And 1 year refers to calendar year. 365 days. Pag sinabing 1 year, 365 days, common year, 366 leap year. If the last day falls on Saturday, Sunday, holiday, or special holiday, non-working holidays, the last day will be the next working day. Kaya very crucial ang 1 day. A student in Legazpi City was able to exercise the right of redemption. Nahabol on the last minute. Bago magsara ang RD. Na-exercise niya ang right of redemption. How would you exercise the right of redemption? Of course, there are a lot of ways. Kunyari, ang worth ng nakamortgage sa iyo ay 10 million. 10 million. Wala ka pantubos ng 10 million. Anong gagawin mo? Kailangan mabit mo 1 year. look for the best lawyer in town and file a case. Any case. Questioning the manner of foreclosure. Or the contract itself. You file, just file. Eh 10 million, meron kang 1 million. O di bayaran mo 1 million yung abogado. Ha? Oh, para at least nakabinbit pa yung 1 year. Makakapag-isip ka mo. At least hindi naging final yung 1 year. So any action, ha? Questioning the manner of extrajudicial foreclosure, ha? Within the redemption period is deemed an action to redeem. There are really a lot of cases like that. Ha? Wala kang pera, pambayad. O di, mag-file ka ng kaso. Eh, wala bang 1 milyon gagastusin mo yan? Siguro, the most 200, 250. Kaya sabi ko rin sa kliyente ko rin, ano, meron ka ba niyan 200,000? O, bayaran mo ko 100. Yung sobra, pambayad natin sa docket fees. Magkano worth ng property mo? 8 million. O, magkano ang kinuha nilang loans? 6.5. O, you compare. O, pwede natin patagalin yan. O, ngayon, nakikipag-areglo, 3.5. Sabi ko, hindi, 2.5. Take it or leave it. O, nag-iisip. Kasi sabi niya sa akin, Tony, baka pwede din sa 3.5. Baka ako, hanggang 2 million lang. Pero kung gusto mo, hindi ikaw bahala. Kasi, ang utang lang talaga, based on my computation, wala yung interest kasi nga illegal eh. Ha? Usurious eh. 5% a month eh. Oh. Yung allowed lang, 3.75 per month. Kita nyo? O, kayong 5%, bumirma na kayo. Pag hindi ka nakapagbayad, magdemanda kayo. O, yun. Kaya kung napapautang kayo, huwag niyong gawin yan. Ano namang remedy kung nagpapautang kayo? Lagay niyo sa kontrata 3.75. O, pero yung excess, ha? Magpabayad kayo. O, bahala na kayo mag-isip kung ano. Ha? Basta, yan ang kaso. Okay? Pag judicial foreclosure, tagal. Ang tawag doon, equity of redemption. Ha? Meron kayong 90 days. Sir, sabi nyo kanina, mas matagal ang judicial foreclosure. Eh, nakalagay rito 90 days. Tama, 90 days. Pero from finality. Ha? Equity of redemption. Yung sinasabi ng equity of redemption, that is from the finality of the decision. Kung hindi kayo nag-apila, okay lang. So 90 days, mabilis. Eh, paabutin ng Supreme Court eh. So it consists the right to redeem the mortgage property within 90 days from the order of foreclosure. Imagine, hindi pa from the time of rendition of decision. Kasi makakapag-order na lang ng foreclosure ng husgado pagka final executory na. Okay? After period expired but before the court confirms the sale, the title of the property vests in the purchaser, and the confirmation of retroactive date of sale. So under the Charter of Philippine National Bank, General Banking Act, the mortgage or successor interest or any judgment credit, the mortgage conferred with the right to redeem the property sold or foreclosed after confirmation by the court of foreclosure sale, which right to be exercised 1 year. So pag bangko, 1 year. 1 year. Date of registration, certificate of sale, and the registry of deeds. Pero pagka korporasyon, 90 days. Nakalagay ba rito? Ayan o. The filing of judicial action itself within the redemption period equivalent to a formal offer to redeem. See? So, umutang, hindi nakapagbayad, na-foreclose. So, may right of redemption. Kung hindi nyo kayo magbayad, mag-file kayo ng kaso. Because filing of judicial action itself is equivalent to formal offer to redeem. Kaya yung iba, utang lang utang eh. Ito, sagot na natin to. Oh, ayan. Foreclose. So, pagka hindi na-redeem, within 1 year, doon pa lang magkakaroon ng absolute ownership. So, kung sino man yung creditor, kunyari, private individual, so he will execute a certificate or rather an affidavit of what? Consolidate ownership. Affidavit of consolidation of ownership. So, na-consolidate na. Kaya, kung magbabayad ng tax, ang counting ng 30-day period is from the expiration of the redemption period. Kunyari, ngayon ang petsa ng 1 year. So, kailan mag-umpisa ang 30 days? Ngayon din. But remember the rule on counting of period. Exclude the first day, but include the last day. So, plus 30 days. So, ngayon 31, March 31, so plus 30, so April 30 will be the last day. Kung ang April 30 fall on Sunday, holiday, then the next business day will be the last day. So, kung hindi na-redeem, sa bangko hindi na-redeem, well, makukonsolidate ang title. Kaya, pag sinabi nyo, tutubusin nyo, hindi nyo matutubos. Yun sinasabi ng bangko, gusto nyo, bilhin nyo, yung buyback. So, sa presyo na nila. Kaya even the pag-ibig, ang problema, pag-ibig. Ito, dalawang beses na ako umawak ng kaso ng kalabang ko pag-ibig. Alam nyo, kaya pala ako, personal ko lang to, wag kung may pag-ibig man dito, hindi ko naman nilalahat. Pero I would tell, personally, that is a bad procedure. Why? It does not comply with the obligation of the state. Bakit? Nawawala yung social responsibility. Bakit? Imagine, ipo-foreclose. Tapos, i-open for sale. Doble ang presyo. Doble. Kung halimbawa ang utang 500,000, alam mo pag na-foreclose, na-consolidate ng ownership, ibebenta under the guise of pasalo, 1.2 million. So the pag-ibig now becomes not a social institution, but rather a financial institution. But the primary duty of pag-ibig is to give, to render, what? Assistance to the middle class, to provide them honest, decent housing. I don't know. Well, yun lang akin. Yun ang naranasan ko bilang lawyer. At the same time, as a practitioner, real estate practitioner. Kaya I discourage my client to buy pasalo. Kako hindi nyo alam ng pasalo. Lalo, bakit yung sasaluhin ng isang bagay na may nakatira pa? Dapat mayroong nakalagay doon, occupied, ganito. Kaya kung kayo broker, huwag kayong tapas-labas mag-o-offer ng pasalo. Baka yung pinapasalo nyo, baka isalubong sa inyo. Nangyayari yan. Baka kala nyo. Baka magurumentado yan. Ako na po ang nakabili nito. Sino kayo? Ako na ang bagong may-ari. Ay, patay kayo. But remember, I'm not discouraging. But I wanted, kung mayroon mga tagapag-ibig dito, kung sino financial or government institution, I would suggest that you let yung procedure nyo naman, huwag naman yung, kasi yung naging experience ko Imagine, kaya pinor-close, kasi dodoble ng presyo, hindi lang doble. 1.2, almost 150% ang increase. O di mababa nga naman kasi ang down payment, maring 60% lang o 10% o 5% lang ang down payment. Then, extended, long term, 15 years, 20 years, depende sa allowed period. Kung bata-bata, di maximum, 25 or 30 years, as the case may be. Kaya mababa. So pagkatapos na ang right of redemption, mako-consolidate ng title. Doon lang babayaran ng capital gains tax or withholding tax. O ano pa ba, bayaran tax. So malilipat ka. Ngayon, ang susunod nun, ejectment na. Paalisin ka na. Palalayasin na yung nakatira. Kasi hindi na ikaw may-ari. Hindi ka basta-basta mapapalayas, so they have to file another case. Yung ejectment, unlawful detainer. Ayan, if the property is not redeemed, the final deed of sale executed, the sheriff in favor of the foreclosure sale shall be registered with the register of deeds. The title of the mortgagor shall be cancelled and a new certificate issued in the name of purchaser. So, yan. Okay, so I think pagka-carp, mahabang redemption period, 5 years. Pero ngayon, yung mga nakuha sa carp, ang dali na ibenta. May release lang yung pre-patent, yung OCT. Sa batas ni Digong, pwede nang ibenta. Samantala nung araw, mag-aantay ka na 10 taon. Ha? Ngayon, wala nang antay-antay. Mainit pa yung titulo, pwede mo lang ibenta. Can banks and other institution acquire title to land subject to mortgage or interest? Yes. Pwede. Kahit 6657 yan, carp law. No? Pwedeng collateral, di ba? Yung land bank. Ano? Land bank ba? Tama, land bank. Yun ang ng agricultural land sa mga sa agricultural carp. Okay, so with that, we're through with this slide. Then let's see the questions. Okay. Tignan natin. Kung ano yung mga okay. If nasa developer pang title pero di pa na-transfer sa amin at di pa na-turn over sa amin, kami po magbabayad ng amilyar. Remember the payment of RPT. Whoever in possession. Kung sino yung nakapossession, siya magbabayad. At kasi payment of tax is not an ownership, evidence of ownership, but evidence of possession. Wala pa sa inyo yung titulo, pero na-turn over na sa inyo. Kung na-turn over ngayon, buwan, Marso, so hindi kayo magbabayad ng amilyar for 2023. But on the next year, kayo na magbabayad. So that is the procedure. Paano yung binili ng lupa, ang lupa nila at pinatira sila sa ibang lupa at nang bumili ng lupa nila, pwede ba sila magdemanda na ipatitle yung nilipatan nila? Well, alam nyo, issue to eh. Binili mo isang lote, hindi pala yung nabili mo, kundi ibang lote. Pwede pagpilitan. Kung ano nakalagay sa lote, yun lang. Unang-una, hindi ka dapat magpatayaw ng bahay mo. Na hindi mo tinitingnan kung saan talaga yung lote mo. Nangyari na yan. Nung araw, nung kami ay aktibo ako sa magbebenta ng subdivision. For all you know, hindi pa na, wala pang titulo, hindi pa na-subdivide. Kwan lang. Mapa lang for purposes of reselling. May puno ng mangga, may puno kung ano, malapit sa creek. Ito, morning sun. Minsan, nakukonvince namin. No? Siyempre, hindi pa ako tapos ng abogasya doon. Nag-aaral pa lang ako ng abogasya. Mas maganda pala pag wala kang galong alam na batas. Mas mapusok ka. Kaya napagaling po mga hente, magbenta. Without regard to existing laws. Ako nahihirapan na ako magbenta ngayon ng project selling. Bakit? Kasi unang-una, pag nakita ko dokumento, hindi ko na binibenta eh. Kasi may problema. Pero nung araw, maganda yan, okay, okay yung titulo niyan. Kasi ang concern ko lang, kumita eh. Mabuhay. O, see? O yan, katulad niyan, bumili kayo ng lupa, sabi niya inyo, oh, ito yung lupa mo. Eh, syempre, anong malay ng ahente? Isa nagbebenta lang. Oh. Kaya you better check. But since we are already professionalized, that's why you have to have a CPD para continuing program, continuing education. Ha? So, alam nyo. Kasi, tulad ngayon, may nakapending ako. Mayroong isang developer, walang license to sell. Nagbebenta ng Rolands, subdivide. Ha? Sa Siargao. Imagine, siyempre, under the guise na maganda ang lote doon sa Siargao because a tourist spot. Yung isang ali naman, bumili under hoping na pagpunta niya sa Siargao, maganda yung nabili niya. Yung pala, kagubatan pa rin ang nabili niya. Yun. O ngayon, talking dito sa title, yun ang problema. Ha? So, you better check your records. Attorney yung girl, pero nakalagay sa TCT married to husband. Namatay, subject for extrajudicial settlement. Kahit mana ni girl. Ang tanong siguro, mayroon bang mana yung asawa doon sa minana nung asawa niya? Ang sagot, mayroon. Kasi compulsory heir ang husband. Yung surviving spouse ay compulsory heir. Kahit mana yan. Pero hindi lahat mabubunda sa kanya. Kasi pag may anak, hati-hati sila ng anak. Pwede bang gamitin ang judicial means as a mode of transfer from tax declaration to original title despite walang kaso? Yes. Hindi ka naman makakakuha ng title kung hindi ka dumaan sa either administrative procedure or administrative proceedings or judicial proceedings. Pag sinabing administrative, tulad halimbawa, yung RA 10,023, diba? Yung land residential pattern. Kung kayo ay nakatira doon for more than 10 years, may bahay kayo doon. Tapos, wala namang nagkiklaim noon. So, through adverse possession, you can file administratively. Pupunta kayo sa DNR, pasukat kayo, kung ito is nasa probinsya, entitled kayo sa 1,000 residential. 1,000 square meters, 750 pag third class. Municipality. First class to second class, 500. Urban, 250. 200 lang. Yan ang ginagawa, administrative proceedings. Pero over and above the minimum, at the maximum rather set by law, under Republic Act 10,023, you go to judicial proceedings. Matagal ka na doon, patutunayan mo lang na more than 30 years ka na nakatira doon. And you are paying the tax. May tax declaration na under ng buyer, pwede ba habulin ng iba? Well, remember, tax declaration is just a proof of possession, but not proof of ownership. But payment of tax, real property tax, coupled with actual possession is the evidence of ownership. Kasi bakit ka magbabayad ng tax kung hindi ikaw nakaposisyon? Di ba? Kaya ka nakaposisyon dahil ikaw may-ari. Sir, paano yung fully paid na property? Need pa ng transfer ng name ng owner. Pero ilang years na di nagpapatransfer, nasa developer pa rin. Pero updated tax. May problema kayo. Ayusin nyo na. Ganyan ang nangyayari palagi. Pag namatay na yung original buyer, nakapangalan pa rin sa developer, hindi may lipat sa tagapagmana. Kasi ang developer, hindi pa nililipat doon sa bumili. Kaya, may mga kaso kaming ganyan. Kaya huwag nyo nang patagalin. Paano makatitle yung kasi steward o yung first land? Hawak barangay, nasunog. Sabi ko nga sa inyo, hindi sila nagbibigay ng steward eh. Stewardship. Paano kung ang buyer ang mortgage niya, binayaran ng siguro, private financing at binabayaran din niya, pero ang bayaran foreclosure na. Pinatransfer kay private institution ng tayo, tapos na-transfer ulit sa ninyo. May problema yan. Dapat, pag kayo nagbabayad, dapat, i-check nyo muna ang titulo o yung kung na-transfer na. Masawa lang nagsangla sa property nila without knowledge yung isa. Paano kaya yung boy? Ang mortgage contract without the marital consent is boy. Ha? Awawa ang nagpautang. Sayang. Attorney, na-option po ang property by non-payment of real estate tax. Pero di pa na-to-take sa title. Ang pinag-usapan naman natin dito, LGU, non-payment of real property tax. So may karapatan ang LGU to hindi to foreclose, to forfeit, to sell the property through public auction. If there is no public bidder, then it will be forfeited in favor of LGU. Ayan, forfeited. May right of redemption din. Ang forfeiture, 1 year din. The same as foreclosure of mortgage. Pwede mo mabawi ng isang anak ang share niya kung yung property na benta ng ibang mga kapatid. Bali, piniki lang name niya. Pwede, annulment of sale. Annulment. Attorney, pag timberland na po nakalagay sa DNR, hindi ko mababago yun para makapitulungan. Well, you apply for reclassification. Mag-apply kayo ng reclassification. Attorney, May 4, magkatabing lots na may beachfront area. Magkapatid yung may-ari with individual titles. Pero pinatula ng isang kapatid yung beachfront. Kasali ang beachfront at 3 kapatid under niya. Legal po ba yun? Well, what I can tell you is that, of course, there is an issuance of title, so it is presumed that it is issued regularly. Presumption lang. Because title issued through fraud or through means of irregularity is void ab initio. So there must be an action in that. There must be a case to be filed in court. In fact, yan ang pinag-aaralan ko ngayon dahil I have a group in I think in Zambales, na napatituluhan. When in fact, it should not be titled because this is accretion land. Accretion. Hindi pwedeng REA ng isang tao kasi is part of parang salvage area. Accretion nasa gitna ng dagat at ng ilog. Magandang lugar eh. Sabi nga sa akin, Tony, gusto mo ng lupa rito. Sabi ko, ang dami kong lupain. Ayan, kukulit. Sabi ko, kung wala kayong pambayad ng reclassification, alam naman mag-abono ako. Mura lang, attorney, yung bayad. Kayo na umayos ng mura. Huwag niyo sabihin sa akin. Kasi hindi ko alam yan, trabaho ka abogado. Pati ba naman kako yung pagbabayad? Kasi mura lang daw, kasi sinisigil daw ng 50,000. Bahala kayo mag-ayos. Wala akong pakialam dyan. Basta ang gusto ko, mayroon kayong certificate to prove that this lot is a product or cannot be titled because this is land of accretion. Pag sinabing accretion, public yan, public land. Walang pwedeng magmay-ari yan. Hindi pwedeng patitulan. Alienable and indisposable. Paano mag-apply? Nag-reserve area ng more than 30 years. Di mag-file kayo ng petition for issuance of original title. Attorney title will undergo extrajudicial settlement. One there do not cooperate. What act in the remaining years do if they want? Go to court. File for judicial sale. Mag-file kayo. Punta kayo sa court. File for petition for letters of administration. There must be somebody that should act as administrator. Paano kayo magbebenta? Kasi walang last will and testament. So, intestate. So, mag-file kayo ng petition for issuance of letters of administration. As a lawyer. Don't do it alone. Attorney, may nabili akong property, naka-tax deed lang. Pero nakapaloob siya sa 14 hectares. Dapat ba i-segregate ko muna yung 300 square meters? Well, that is your prerogative. CLOA after 10 years, pwede benta? No. Paano mo ibebenta ang CLOA? Imperfect title yan. Certificate of Land Ownership Award lang yan. So, it must be converted to OCT. Attorney, is there a possibility magawa ng title yung settlers na 50 years above nang makatira sa property pero walang title? Only paying tax. So, you file to adverse possession. Wala na kasing pre-patent. Attorney, private lot po, 25 years na po. Binabayaran ng royalty tax ng laton. Parang inabandon na. Pwede mo bang mag-petition ang mga informal settlers sa city government, expropriate ang lot, tapos sa city government na lang bili ng mga occupants ang lot. They are occupying. Well, maganda yan. Hindi sa pagmamayabang. I've been also in politics. I did not only run once, twice, but thrice. I'm promising every during campaign period, I'm promising to the electorates that if ever I win, I will give them 3 hectares of lot. Free. Unfortunately, I lost. So, hindi ko sila binibigyan ng lote. Asan ang lote? Doon sa Mindanao. IP. Even here in Luzon. I'm not bragging. Alam nyo ba, ang IP napaka-powerful. Sabi ko nga sa mga brokers ay magulos dili kayo, kayo benta ng benta. Baka masagasaan yung mga IP, yung ancestral domain. Maraming ganyan, nagbebenta. Ancestral domain, may tax deck, may titulo. Alam nyo ba kahit may titulo yan? Ancestral domain yan. Pag napatunayan yan, part of ancestral domain, regardless which you have a title or not, it could be annulled. You see? That is the extent of IP. Hindi po indigent ang IP, indigenous. The most powerful class of people on earth. Even in US, the Texas IP, most powerful. Even they are not paying tax because they are the aborigines, they are the IP. Hindi nagbabayad po ang mga yung Indian. Binibigyan ba sila ng allowance? Where does dash in pago belongs? Judicial or extrajudicial? Extrajudicial. Hindi po kasama sa judicial ang extrajudicial ang dash in pago. Ibig sabihin yan, dash in payment, sale in payment of existing obligation. Attorney, if this is na po yung one of the heirs, need po ba ilagay sa AG's document lahat ng names ng mga heirs ng deceased heir? Well, you better consult. I cannot discuss it publicly. That is violation. Why? There are a lot of cases like that. So I don't want to preempt what you are going to do, depending on the circumstance. There's a lot of ways how to do it in a legal way. Attorney, ang lupa ay nagdaan sa ejectment decision ng court is partial. Party na nakuha ng owner ang property din, may portion na nagpile na naman ang owner ng recovery. Yung part na nakuha ng owner, yung lot ba, di ba mabigyan ng barangay at city hall ng fencing permit? Well, problema yan. Depende yan kung sino ka magkakampi. Ngayon, meron akong konsalongga po, ayaw daw ng barangay. Dumulog sa kanila magre-reklamo dahil hindi raw usapin sa barangay. Sabi ko, sabi mo doon sa barangay, mag-aaral ng barangay settlement law at tarungan pang barangay. Kasi ang usapin ng ejectment, dapat dumaan sa barangay. Maliban lang kung ito exemption. Kung ang nagkakaso ay korporasyon. Pero kung individual, dapat dumaan sa barangay at magkasama sila sa isang komunidad. transfer ang isang property na by way of law as a DAR, pero dapat po extrajudicial settlement of estate ang process. Patay po ang owner, pwede mo bang magabol ng ibang heirs? Yes. Meron silang right of preemption or right of first refusal. Kung, not only that, bilang heirs, may karapatan sila. Oh, bakit hindi sila kasali sa hatian? O yun, in fact, kasama rin yan kahit tenant. Hindi na sa may-ari. Yung tinatawag na leasehold contract. Perpetual leasehold contract. Oh. I was able, we siblings, we are able to acquire agricultural land by exercising the right of first refusal. Bibenta ng may-ari ng mga heirs. Patay na yung original na may-ari, tax deck lang. Ay yung tatay ko, kami ang nagsaka noon for more than 30 years. Binibenta na. O di, in-over sa amin, binili namin. So, sa amin na ngayon. Okay, so I think, thank you very much. We have already overtime, no? Unless may pahabol pa, bigyan ko kayo ng 5 minutes. O, 51 lang daw sumagot. Samantala 300 plus kayo. Bakit? Nahiya ba kayo mag-evaluate? Sabihin nyo. Ang totoo. How can you distinguish in public domain? Well, ang pinakamainam niyan, punta kayo sa local assessor, sa tax mapping. Alamin nyo kung ano yung mga public domain, saka yung alienable disposable. Yun ang the best way how to pero minsan okay, so well done. Well done na. Okay, so maraming salamat sa mga kakilala ko na nandyan ngayon, na hindi kayong pakilala. Sana mayroon akong naibahagi sa inyo, ha? Kasi yung aking binahagi sa inyo, maaaring may decision na o wala pa, pero yan ay aking actual na ginagampanan, karanasan bilang ahente, bilang abogado. Kaya, if you want a private consultation, I am just text away. Ha? Ito nga maraming tumatawag, hindi ko alam kung sino-sino eh. You want to call me, just text me first, then I respond. Pero pag hindi kayo nag-text kung sino kayo, I will not answer your phone kahit na emergency. Nahuli kayo ng police. Tawagan nyo ako. Auhuli ko kayo. Para maayos. Kasi walang kaso. Alam niyo yung police, pag may kaso, talakot sa abogado. Pero, pag nandun sa loob ng presinto, takot ang abogado sa police. Ha? Kaya ang number one technique, dalhin nyo sa husgado ang kaso. Ha? That is my experience. Bakit? Naging abogado ako ng kapulisan ng Maynila. Kaya alam ko pa sikot-sikot. Pati mga scammer, ganyan. Lalo sa lupa. Naku, ang dami dyan magagaling. Nung araw, naalala ko, meron akong mga ahente. Mayroong magician. Mayroong nag-hypnotize. Nakapag-pirma na hindi niya alam. Ako hinahabol kasi ako broker eh. Kita nyo? Kaya labas-masok ako sa kulungan nun. Bakit? Para tubusin mga ahente ko. Grabe. But those are things of the past whereby I learn a lot and I can share it with you. Lalo na pag nung naging ahente na ako, naging broker na ako, at nag-abogado. Kaya with that, I can say that passion ko ay to teach. Because I started teaching at the age of 21. Kaya lang ngayon, siyempre, pang sum-sum na lang tayo. Ayoko na lang classroom. Okay, so marami ng pasakali, marami ng dagdag. Mabuhay po kayong lahat. Salamat po. Enria, ngayon nakita ko
Thank you po.
ang daming umattend, ha?
Thank you, Atty. Balmas.
Thank you,
Bye-bye.
Atty.
Thank you, attorney. Thank you, everyone.
Thank you.
Good
Thank you
afternoon.
very much.
Thank you, Atty. Thank you po. Thank you po.
Thank you.
Thank you po. Thank you po,
Thank you,
Atty.
everyone.
Thank you po.
Nakatapos din ako ng isang araw. What to for? Meron pa ako bukas. 2 araw pa.
Asa naman na eh.